if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you're requesting. People versus Eason, submitted. Rivera versus 95th and 3rd. 6 and 2 and 5. Bank of New York v. Miller. Yes. I'm sorry. Let me just announce that R. Tawana and Michael G. is submitted. And now on to Bank of New York versus Miller. I'll give you 5 and 2 and 4. Emic Corp v. Baron Blat. 6 and 2 and 5. Okay, Pearl Bud Realty and Guide New York City, you have 2 appeals on, so we're going to hear them together. Let me hear from Guide first. Is Guide here? You're from Pearl Bud, I take it. Huh. Do you wish to submit, or would you like to say something? Very well. That's submitted. Haywood versus Site 4 DSA owner. 5 and 2 and 4. Thank you. People versus Nicholas Johnson. 5 and 2 and 4. I'm not sure I'm pronouncing the first name correctly. Noy versus Amelia. Anyone here on Noy versus Amelia or Amelia? Do you see the respondent here? Do you wish to be heard? Do you wish to be heard briefly? I'll give you 3 minutes. Cortez versus New York City Housing Authority. Counsel, who are you here for? Are you for housing? Okay, we'll take it on submission. Thank you. 120 Lexington Avenue versus Wesco Insurance. 5 and 2 and 5. Okay, People versus Julian Liriano. Submission. And Kings County Hospital versus Rebo is already on submit. Okay, call the first case. Rivera versus 95th and 3rd. Please.
May it please the Court, Your Honor, I'm Martin Moskowitz from Goreb and Associates on behalf of the plaintiff appellant Fausto Rivera. Mr. Rivera's accident occurred during...
Yeah, Mr. Moskowitz, on your 2 briefs, your initial brief, and there seems to be a discrepancy between the accident and how it occurred. Now, they're mutually exclusive narratives, I think. So how did he injure his hand? Was it by the fragment of rock that fell off the larger piece of rock, or was it the pendulum that swung with the larger rock on it?
And counsel, in your answer, do you mind just speaking into the microphone? Just pulling it up and speaking into it?
I'm sorry?
Do you mind speaking into the microphone, just pulling it up and speaking into it?
Okay, am I able to be heard better? Okay. So my client's working on...
I still can't hear you that well, so...
My client is working on a 6-foot elevated surface. And based on that, the lower corner that fell over would not have been what hit him. He was actually stepping out of the way of the larger upper portion of the stone that swung. However, I would say that under this court's decision in Sanchez versus 1 Burgess Road, 195 83rd 531, he doesn't have to know the precise manner in which it happened.
Counsel, you have to commit, I think, in the facts of this case, don't you? I mean, because the part of the rock that fell off fell to the right and rather far away from where his hand was, his left hand, which is the hand that was crushed.
It fell, Your Honor.
What is the version, counsel? Just tell me what happened here.
The version is the larger stone hit him. That would be the correct version because he's at an elevated height.
Okay, counsel, that leads me to another question. Your expert, Mr. Sokoloff, analyzed the injury and the circumstances as resulting from the broken rock segment hitting plaintiff's hand. Now that you're saying he was injured by the larger part of that rock, how does that affect Mr. Sokoloff's analysis of the dangers presented by these events?
Well, it doesn't affect at all the fact that his hand shouldn't have been there guiding the stone because there should have been taglines, which isn't really part of this appeal. But this is still a gravity-related accident during hoisting. And the case law in this department is very clear, and also through the Runner case.
I'm sorry, go ahead.
Well, in this department, Norton versus the City of New York, where there was a boom-type truck lifting a load to raise it up onto a building, they lost control of the load. It went sideways towards the plaintiff who was on the truck, and it struck him from the side. And this court said that the loss of control of this load during lifting was a gravity-related accident that was governed under 240, and that created 240 liability, even though he was also knocked off of the truck to the ground, and that was another 240, liability there.
Counsel, I'm surprised by your saying that taglines aren't a part of your claim because for two reasons. One, your expert talks at great length about taglines, and also because if the use of taglines can prevent the swinging of a heavy object that's caused in part by gravity. So why aren't taglines part, excuse me, why aren't
the 241
excuse me.
Counsel, it's very bad form to interrupt the judge
My
when they're talking.
apologies, Judge.
So explain to me why taglines are not part of your claim.
No, the 241 claim was granted by the lower court as being prima facie, and this appeal is of the dismissal of the 240.
Right.
We are saying that taglines are essential, but it's not. It was found by the court that should be the law of the court. It's not part of this appeal that the 241-6 stands because of the absence of taglines.
But doesn't the absence of taglines also affect the, isn't that also a part of arguing that it's a gravity-related accident?
Well, it is a gravity-related accident because of the hoisting.
Well, would the taglines be a necessary safety device under Labor Law 240?
It would be in this instance because of the fact that they lost control of the stone and it swung and crushed his hand. So, of course, if his hand wasn't there to begin with, then, the accident wouldn't have occurred if he had taglines. But the important thing here is this is not a tension-related accident. This is a gravity-related accident, just like with Runner, where the ball's being lowered and the workers pulled sideways by the rigging into the ball. Here, the stone is being lifted. It's 3,500 pounds. It's being lifted, and they're struggling to lift it with the hoist, and they lose control of it, and it swings and strikes my client. And Runner itself attacks the Topher case as not being gravity-related because of it not being an object that's being lowered or lifted. If they were moving the stone across the courtyard to the place where they were going to hoist it and a cable broke loose, it would be a different story. If the stone hit somebody while being wheeled across the courtyard, it's a different story. But it's definitely a gravity-related occurrence when you're lifting 3,500 pounds and struggling to do so with a hoist machine.
Thank you. You have time in rebuttal.
Thank you.
Your Honors, I may please the court. Jung-Hoon Yang for defendants, respondents. And since my friend admitted that as to how the accident occurred, I want to focus on the law and how it should apply to the facts of this case. Under the leading case law, the Court of Appeals case law, such as Runner, Gasquez, and Walensky, the relevant inquiry is whether the accident was the accident a direct consequence of the application of the force of gravity to an object or a person. And here, that
In part, what was happening here is that the rock was swinging to the left. Wasn't that in part the effect of gravity on it, that it caused it to swing in a pendulum-like motion?
Well, we respectfully disagree as to that motion being applied as being affected by gravity. Well, because, well, first of all, that rock moved to the left, and according to the plaintiff, it moved to the left, and I quote, due to the pressure of the hoist.
Well, but the plaintiff is not an expert on the reasons why something moves, but his expert was very clear that the movement of the rock was a pendulum-like effect caused by gravity. Why wouldn't, I didn't see in any way that your expert countered that.
Well, our expert actually did say that the cause of the accident was the rock being broken, and not so much of the gravity, and that was on, I believe, on.
I didn't specifically see anything in your expert's report explaining why he believed that gravity was no part of the cause of this accident.
That's correct, Your Honor. It didn't specifically say that.
He didn't say that.
That's correct, Your Honor. But he did say that the primary cause of the accident was the rock being broken. And going back to what...
Counsel, you mentioned Walensky, and Walensky cites Runner. In Runner, as you know, there was lateral movement of a metal bar that was on the same level as the plaintiff, and that metal bar injured the plaintiff because the rope that was tied around the bar was insufficient to regulate the descent of a large wheel of wire that weighed 800 pounds. How do you differentiate the facts in Runner, which were favorably cited in Walensky, the case that you just referenced? How do you distinguish Runner from this matter before us today?
Yes, Your Honor. So in Runner, as Your Honor just mentioned, what caused that plaintiff to be pulled horizontally was the force created by that wheel as it descended down the stairs. So clearly there was that gravity force that was going downward, and that force was obviously pulling the plaintiff horizontally. But here we don't have anything going downward. It was
Also, it doesn't have to go downward. A pendulum, one of the forces always acting on a pendulum is gravity. There might also be air resistance, and also whatever is suspending the pendulum could also have more elasticity in it that affects how it swings. But gravity necessarily affects a pendulum. So unless you're saying this is not a pendulum, you can't say it's not gravity related.
Well, I'm not sure if this is like this. We can say for certain that this was a pendulum, although the expert, Mr. Sokolov, said that this was a pendulum. But our version, although this was not fully briefed, I guess, in our brief, the motion of the rock, it first hit, it moved to the left and hit, and then it sort of moved the other way.
Well, counsel, a little different. If we were to back up a little bit, this very large stone, 3,500 pounds, which is a beautiful piece, right, with a hole in it, it's affixed to a base, right, and all the segments are removed bit by bit, hoisted piece by piece after the epoxy is removed. But the bottom piece, according to the testimony of the plaintiff, could not be removed from the epoxy that it affixed it to its base. Therefore, isn't the movement upwards first, and is it upwards where the hoist is trying to lift that remaining piece off its base? And doesn't the accident take place as a result of the upwards movement, which then breaks that remaining piece off its I'm going to call it a pedestal, it's not its base, and then it swings?
Yes, sorry. Yes, Your Honor. So I do admit that there at some point has to be uprooted, as Your Honor suggested. But I think this is different from a case where an object is already suspended midair and it begins to swing. And in that case, I agree with Your Honors that would be a pendulum-like movement. But here it was being uprooted from the ground as it was affixed to the floor. And so it's like, I believe it's simultaneous, a lateral plus.
Again, I'm sorry, the last part?
I believe it's a simultaneous movement, an upward motion combined with a lateral movement. Thank you.
Any
Your
other
Honor.
questions? Thank you, counsel.
Your Honors, they exerted a great deal of force to lift this stone, and they tried for 15 minutes. And as they amped it up and they finally were able to lift it from its base, it breaks. And that is gravity. That is the force they applied and it lifting and causing it to swing. If it was a smooth pickup and it was properly planned and properly done and they had the taglines, the accident wouldn't have happened, but it certainly is a gravity-related occurrence under the case law that we cited.
Any other questions? Thank you, counsel. Thank you both. Bank of New York versus Miller. Please.
May it please the court. Good afternoon, Your Honors. Christopher Volante, Rosenberg, Fortuna, and Laitman for the appellant. We submit in this case the order of the Supreme Court needs to be reversed, primarily because when you look at the plain wording of the statute, here being RPAPL 1351, and its legislative history, and particularly its amendment and other amendments that were in the same bill, it's clear that this provision was not intended by the legislator to be extendable.
How do you
Isn't that
compare that? with-
I'm sorry.
How do you compare that with CPLR 2004, which says that the court may extend the time affixed by any statute, rule, or order doing any act, unless, yeah.
Right, so I think there are several answers to that. First of all, just a general point, CPLR 2004, as you just cited, says statute, rule, or order. It doesn't say anything about judgment, which is what this is. So we would submit it doesn't even apply to a judgment. This court's never applied it to a judgment. It's never applied it, more importantly, outside of the CPLR, which this is. This is in the RPAPL, which makes clear when you look overall at the RPAPL, basic statutory interpretation, you have to look at the body of law as a whole. There are several statutes we cite in our brief where there's an explicit good cause carve out that's in the statute. So the legislator knows when it's dealing with the RPAPL when it wants to give a good cause exception, when it doesn't.
You would agree that there's no fixed expiration date for a judgment for foreclosure and sale, right?
In the sense that there is case law, obviously, that there's no fixed expiration of a JFS because it's not a money judgment. But we also cite case law in our brief just in general that even in those situations, a JFS can become stale when the circumstances warrant. It's Court of Appeals case law to that effect. But as far as CPLR 2004, again, even the plaintiff's strained argument to the contrary is, well, 2004 applies to RPAPL 1351 because there's no good cause carve-out explicit there, but it doesn't apply to 1353.
Counsel, isn't that quote-unquote strained interpretation just backed by overwhelming authority from places not that are the first department, but nonetheless in the second department, a number of trial courts have held that, contrary to your position, that 2004 does apply?
With regard to the second department decisions, obviously the things I would point out, one, not that I have to inform this court that they're not bound by the second department, but beyond that, there were other factors in play in those cases which aren't here, which are, for example, bankruptcy stays, and that actually stays time, a time limit, as opposed to here, there's no kinds of stays. And also, to my knowledge at least, in that case, the applicability of 2004 was taken as a given. And the question was, does 2004, did they meet the standard? There wasn't any specific challenge to whether 1351 could be extended.
So to the extent that the 1351 is intended to get properties back on the market and not just lie vacant, right?
Right.
How is your client injured in any way? Or how has your client benefited by any delay? Looking at it from both sides,
So I think as it's the general matter, I think looking at the absence of potentially the absence of prejudice from my client is the wrong a standard to look at, because even if the court was going to apply 2004 to this, the standard would be, did the plaintiff show good cause, not whether we were injured. And quite frankly, the legislature, we would submit, made clear in the statute, if it wanted to put in a good cause carve-out, it could have, just as it did in the same bill that amended 1351 when it put a good cause carve-out in 1353. And to read everything together and to read it in harmony, which courts are required to do, you have to treat them the same. If anything, to rule otherwise would treat 1351 separate from all other Article 13 time provisions that otherwise have,
So you're saying
requirements
that-
of strict compliance.
You're saying that RPAPL Section 1304, which applies to 90-day notices as a condition precedent
Right.
to filing suit, and RPAPL 1371, which applies to 90-day deadline to move for a deficiency judgment. You're saying that they're just the same as 1351 because they happen to be in the same section of the RPAPL?
Well, they obviously all deal with the foreclosure process, different aspects of the foreclosure process, obviously, so there's not a substantive relation, but it's part of the overall body of law. And in general, as there hasn't been other situations with dealing with deadlines contained within Article 13 of the RPAPL, where a court has said, well, these don't have to be strictly complied with. These can be extended. There's extensive case law on 1304, 1371. These can't be extended. Or if there can be extended, you have statutes like 1353, like other statutes in the RPAPL, which have explicit carve-outs.
Thank you.
Thank you, counsel. You got time in rebuttal. Please.
May it please the court, my name is Eliza Malouf, and I represent the plaintiff respondent, Bank of New York Mellon. As a threshold matter, this court doesn't even need to consider the arguments that have been raised relating to the legislative history and the statutory
Yeah,
interpretation.
counsel, I don't buy that one. I'm sorry. You're saying it doesn't affect a substantial right? Is that your argument?
That's correct.
What
Your
if you'd lost below? Wouldn't you be kicking and screaming saying my substantial right has been prejudiced?
Probably.
Okay, move on to the next argument, I would say.
Fair enough. So as it applies to 1351 doesn't mandate that a sale occur within 90 days. It mandates that the judgment, foreclosure, and sale direct that a sale occur within 90 days. And it is well settled under CPLR 2004 and under the inherent authority of the court that those deadlines can be extended. And that's what happened here. The court said, sorry, you look like you're about to ask a question. Oh, sorry.
No, please.
The court said that under looking at CPLR 2004, which allows a court to extend any order statutory deadline, that it had the right under 1351 to do that. And 1351, the legislative history does not prohibit the court from finding that it's a non-extendable deadline. If you look at the other deadlines, for example, that are referenced, those deadlines have a specific carve-out which makes CPLR 2004 not applicable. So
Did your client arbitrarily delay?
No, Your Honor.
Yeah.
There was no arbitrary delay. What happened here was within 2 days or so of the notice of entry of the judgment, foreclosure, and sale, there was an immediate appeal to the Court of Appeals, followed
By whom?
by the appellant, Your Honor, followed immediately by an appeal to this court, which was then withdrawn after the Court of Appeals decision denied the.
Have both sides appealed? Have both sides filed motions? Or is this?
These were all motions filed. I'm sorry, I didn't mean to cut you off.
I'm asking, was there delay on one side or the other such that it would negate good cause in your making this application?
All of the delays, all of the motions that were filed by the appellant in this case, either at the trial court level or at this court or at the Court of Appeals level. And the reason that no sale occurred in that period is because it would have been pointless to have gone forward with a sale where there's a possibility that the court could then find that the JFS should be reversed. CPLR 2004 doesn't say that we need to show good cause for why we delayed in asking for an extension. It just needs to show good cause in granting the extension. And the good cause here is there is no point in having a sale when there's a very real possibility that the court could subsequently determine that the sale should be reversed. And that is what happened here, where, you know, and even had we requested an extension earlier, or had we gone forward with the sale, for example, earlier, odds are quite good that my friend on the other side would have requested a stay of the judicial sale. So the same, quote, prejudice that they're suffering, i.e. a delay in the sale, would have resulted regardless. And on top of that, they haven't actually been able to show any sort of prejudice. The prejudice that's presumably occurred here is the theoretical possibility that the appellant may not be able to recover a surplus, but they haven't put forward any evidence that there would even be a surplus of any kind. It's just as equally likely that the property would sell for below what the JFS says that we're entitled to recover. And in that event, then there would be no recovery anyway. And on top of that, if there was a feeling or a sense that they were not going to, I'm sorry, I see my—
Please continue.
If there was not a concern that they were not going to recover surplus, the correct procedural option would have been to request the court to modify the JFS to cut off any interest that accrued between the time the JFS entered and now. That did not happen in this case.
Thank you very much.
Thank you, Your Honor. I want to spend most of my rebuttal time talking about their excuses under 2004 to the extent that the court's going to apply it. But before we do that, I just want to make two quick points. First, to the idea that 1351 only states you have to state a sale in the JFS take place in 90 days, but you don't have to actually do a sale in 90 days. I mean, I think that's a strained logic that a judgment has to say you have to make a sale in 90 days, but then you don't actually have to do it. I also, to the extent that they bring up lack of prejudice to us, again, that is, even under 2004, that's not the standard. They have to show good cause, which they didn't do here. I mean, essentially their argument is we can't walk and chew gum at the same time.
Your client could have sold the property, the apartment, prior to foreclosure, right?
Yeah, assumingly they could have sold the property, sure.
Okay.
But as far as their showing of good cause, again, their argument is we had pending motions, which, by the way, were adjudicated a year and a half before they made this motion. The motion was made 3 years after the JFS was filed. Even the renewal motions that they cite that we made were made a year after the JFS was issued. There were no stays. There was nothing that stopped them from doing anything. The fact that they took a litigation strategy doesn't mean they have good cause to not move when they could have at any time. And again, the argument really boiling down to we can't walk and chew gum at the same time. We can't do two things. We can't fight an appeal and make a motion or make a motion to extend or to actually conduct the sale is tenuous, and I don't think that actually constitutes good cause. The other one, the other excuse, which my adversary here didn't raise, is the boogeyman of COVID. But that's not really an excuse here, as we pointed out in our brief. First of all, by the time the JFS was issued, the initial COVID tolls and executive orders were largely done. When CFPA was passed in December of 2020, it didn't apply here because we're an LLC. We're not a natural person. And even if CFPA did apply, because there was no hardship declaration, it would have ended in February 2021, 2.5 years before they made this motion. So we would submit, even if 2004 was going to apply, there's no good cause here.
Thank you, counsel.
Thank you
both. Emic Corp v. Baron Blat. Please, counsel.
May it please the court. So this case has been around almost 10 years,
Counsel,
but it's almost
Could
ready
you
for...
make your notice of appearance, please?
I'm sorry?
Could you give your appearance, please?
Oh, sorry. Richard Schoenstein, Your Honor, Tartar, Krinsky, and Drogan for the appellants. Got lost in my enthusiasm for a second. The point of this appeal is to put some parameters around damages that might be recovered at trial. The case is about individual defendants who left Apple Corporation in September of 2013. Apple went out of business 5 months later, February of 2014, but they seek damages relating to commissions up through 2021. 8 years.
It seems to me their theory is disgorgement, and why isn't that an equitable remedy?
Okay, disgorgement is the theory. It used to be lost profits. Disgorgement typically has to do, Your Honor, with recovering amounts that were paid to an unfaithful servant by an employer. That's not the issue here. These were commission-only salespeople. EMIC doesn't cite a single case.
Their only form of compensation was commissions, right, when they worked for Apple? I'm sorry, their only type of compensation when they worked for Apple were commissions, correct?
Correct.
Okay.
That's correct, Your Honor. And we cite case law, Your Honor, on this disgorgement theory. First of all, the IDT Corp case from the Court of Appeals, that says disgorgement under an unjust enrichment theory didn't work because the monies hadn't been paid by the plaintiff. They had been paid by a third party. You can't disgorge money that a third party
What
paid.
about pursuant to the fiduciary duty claim?
Well, the fiduciary duty claim, Your Honor, is a lost profit claim. It's not a disgorgement claim. And the Pure Power boot camp case that we cite says that to get disgorgement in a situation like this, you need two things. The plaintiff needs to show a tangible expectancy in the commissions or money that was going to come in, and that the conduct of the defendant is a substantial factor in the loss. Neither can be proved here because the borrowers didn't have contracts with Apple. They had no obligation to do business with Apple. These are mortgage borrowers who will bounce from lender to lender until they find terms they like. So Apple didn't have a tangible expectancy in anything, and there's no—
Is causation a question for the finder of fact?
There's no evidence of cause. It would be, Your Honor, except there's zero evidence here. The evidence is that the defendants allegedly took stuff with them they shouldn't have. There's no evidence that anything they took led to a single transaction. There's no evidence that material they took allowed them to get in contact with a borrower.
I guess the part that's a question for me, the material that they took were customer databases, right?
No, they took Outlook contact lists. They took the list that's on
I
your
know
cell
what
phone.
an Outlook contact.
But it wasn't just the name and address, counsel. It sounded like there were social security numbers in there, very sensitive financial information about the individual client that could be used to pitch.
There was some
the job to
material, Your Honor. They
mortgage.
copied the first page of some mortgage applications that had some of that data. All of the evidence is that material was promptly discarded. There's no evidence. There's zero evidence
But
in the
isn't
record.
the first part, again, you just acknowledged that they took documents that had confidential client information.
But there's no evidence, Your Honor. That doesn't get you to generating commissions. There's no evidence that links any of that.
Well, let's talk
to
about the
commission.
Guard Hill employment agreement that required that each of the individual defendants would send email announcements to his or her database of clients and referral sources within 14 days of employment with the company.
That's right,
Where
Your
were
Honor.
these databases supposed to come from? Isn't there a not logical nexus here?
No, there's two different things. The database it's just an address list. It's the addresses you have on your
But
phone.
if it's not yours, so what?
Well, it is yours, Your Honor. It's your friends and family. It's your contacts. It wasn't.
Including possibly your professional contacts. So it's
No,
not
you might have
just-
professional contacts, but you're making law. You would be making law respectfully that nobody can take the address information on their phone with them to a new
Counsel, I
employer.
think we're making a distinction between the Apple Outlook contacts list and one's personal contact.
There is no Outlook. There is no Apple contact list. There is no Apple. Apple admitted they don't have customer lists. We're only talking about the Outlook contact list that were maintained by the individuals.
So you're
That's the
saying
distinction.
that personal information supplied by potential borrowers, that information was merged with personal information of each individual broker?
They just put it in there. They just entered it on their phones. Name, address, phone number, email address.
But they only have that information as it relates to their position, their work with Apple. They didn't have that because they met them out at a social environment. They had it because of the work that they were doing
Well, some of them, yes. Some of them because they were friends and family. I mean, some of their clients were people they knew for years that were personal friends and family.
Counsel, should we draw, or is it possible that the trial court drew a negative inference from the fact that the files were destroyed on the Apple computers? In other words, they not only took the information, but they took it out of the...
In terms of liability, that's possible, Your Honor, but I'm here about damages. And I want to say before my time runs, unjust enrichment has to go. There were contracts here between Apple and the individuals. They can't have an unjust
You're
enrichment
saying
claim.
that the unjust enrichment cause of action is duplicative, yes?
I'm sorry?
You're saying it's duplicative?
It's duplicative of the contract claim and of the breach of fiduciary duty claim. It needs to be out of the case entirely.
Thank you, counsel. On your rebuttal, we should talk about your counterclaims, too.
Happy to.
Good afternoon, Your Honors. Jonathan Rogan on behalf of the plaintiff respondent. Judge Moulton, I think you got it just right at the beginning when you talked about it being a question for the jury. Pure Power was a post-trial decision by the
Counsel,
court.
lower the mic, please, so that we
Yeah,
can...
we're having a hard time hearing today. I don't know why.
Sorry,
Thank you.
I thought I was taller than I am. So Pure Power was a post-trial decision by a judge based on evidence presented to him, the fact finder. Okay, here we're talking about a summary judgment motion. And when Pure Power focused on two things, they're saying the first factor is, was the breach of the duty of loyalty a substantial factor in the commissions that these guys ended up earning at Guard Hill? And frankly, I find it like impossible to conceive of an argument that says it wasn't. They copied, and I'm even just talking about the contact lists, not the mortgage forms they took, right? They copied their contact lists. Two of them purposely tried to delete them, right? So Apple wouldn't have them. They then bring those contact lists, which are maintained by them on Apple's network as part of their job at Apple for which they are being compensated. We're not talking about contact lists that they just kept on their personal computers at home of their friends and family. They then provide that contact list to Guard Hill pursuant to their contract. Guard Hill sends out an email blast to all of these people, all of their people on the contact list, letting them know that these 4 people now work at Guard Hill, right? When these people then either refinance or sell their house and buy a new one, and they're looking for a mortgage, and they now contact these individuals at Guard Hill, how is it that they can say that there's not even a question of fact as to whether the taking of the contact lists was a substantial factor in their getting these commissions from these new borrowers? I mean, Alan Rosenbaum, the president of Guard Hill, testified that Outlook contact lists are the lifeblood of a mortgage broker. When he was asked about the 1003s and the 1008s, he said that would help us get refinance business.
Well, sure, that's true, but what about all the other variables that go into whether people choose this mortgage against another mortgage? And that's your opponent's point, which is that causation is very difficult to parse here.
Well, that goes to I think, the tangible expectancy of the future commissions. And frankly, even in Pure Power, whereas the court there noted that the Pure Power gym didn't have, like the customers of the gym had monthly cancellation ability to get out, so there was no contractual requirement. But they ultimately found that as to the 20 customers who left Pure Power for the new gym, that the calculation of the lost gym fees from those people was too speculative. Here, we're talking about a business that doesn't have monthly charges, but we have everyone acknowledging that these contacts are important. And these are people who already have mortgages because they did mortgages at Apple. And it's because these mortgage loan officers know that there is repeat business to be had when people either buy and sell their houses or refinance.
Counsel, I need to ask you a damages question about disgorgement. Can one get disgorgement if one has only a breach of fiduciary duty claim? Can you get disgorgement as damages? In other words, Apple went out of business, so they're not going to do anything with this business after they go out of business. So then, under a breach of fiduciary duty claim, is the remedy to get whatever monies were realized by the unfaithful employees? And that's disgorgement. So in other words, is disgorgement a type of damages one can get if one prevails on one's fiduciary duty claim?
Under Gomez and Epstein Engineering, absolutely. And there's you have a choice. You can, as a plaintiff, you can pursue lost profits, or you can pursue disgorgement. And they can say all they want about a lost profits claim being speculative, but it could be speculative, and that's maybe why the plaintiff chooses to go disgorgement. And I will say, even though Mr. Schoenstein said that lost profits was the only damages we're seeking here, if you look at the actual interrogatory responses, right, which are at start at page The operative ones are at 281 to 284 of the record. The interrogatory asked us to identify our categories of compensatory damages, and we identified for each of the 4 mortgage loan officers the commissions for borrowers that closed before they left, before Apple went out of business, and after went out of business. So for them to say they're surprised that we were trying to disgorge them of, I mean, and the information, like their actual calculations in the interrogatory responses of what these future commissions are worth in terms of damages, and that's because they were produced to us during discovery. We were talking about these future commissions for years, so we have always asserted, maybe we didn't use the word disgorgement, but we didn't have to. We asserted breach of fiduciary duty. They asked us, what kind of damage did you suffer? We said, among other items, these future damages. On the aiding and abetting claim, that wasn't really dealt with too much, I think, in Mr. Schoenstein's presentation or in their reply brief, but I just want to be clear that apart from the individual defendant's wrongdoing that is recited in our brief, we have Guard Hill, which required them to bring their contact lists, assists Baron Blat in extracting his contact lists remotely off of Apple's network, helps Fuhrer with the 1003s and the 1008s type information into Guard Hill's network. When the 3 of the 4 went in over Labor Day weekend when no one was going to be there to take everything, all the 1003s and 1008s, all of that taking happened after Unger spoke to Rosenbaum after he sent him an email that said, asking about taking current loan files, and then he tells the other guys by text, he said it's okay.
I think you set forth that sequence in your brief very well.
Okay.
Thank you.
Thank you.
Your Honors, on disgorgement, I just want to add to the argument I've already made. There's no basis for disgorgement against Guard Hill on an aiding and abetting breach of fiduciary duty claim. There's no case law cited that would permit disgorgement. You would have to show actual damages sustained by Apple, and it went out of business in February 2014. That's one of our points. Either
Went out of business 5 months after the individual defendants went to Guard Hill, right?
correct.
So isn't that the beginning of a period that would be applicable as far as their damages go?
There's no claim that going out of business had anything to do with the guys.
Why are you
leaving.
bringing it up?
Because they weren't able, because Apple couldn't generate commissions. Apple couldn't make profits.
They could during that 5-month period.
Yes, during the 5 months, but not after. And we want to put the right parameters that after February 2014 in particular. Now, Justice Moulton asked about our counterclaim. Labor law section 191(1)(c) requires employers to set forth the terms of employment in a commission agreement. There's nothing in the compensation agreements here, and they're all in evidence in the record that says if you leave after you procure a deal, you don't get paid. That's the key. Apple had the burden to put that in their compensation agreement, and if they didn't, the presumption under the labor law is in favor of the sales.
What's your best case on that? Because I didn't really see that argument so strongly.
I'm looking at Aberdeen Council, and Aberdeen says that an at-will employee is not entitled to post-termination conditions, although the parties are certainly able to agree to that.
I don't think that's considering the labor law section, Your Honor. So we cited a bunch of cases at our brief in pages 44 and 45, the Abney and the Udall cases, and also SPRE Realty.
Thank you.
Thank you.
Counsel, thank you both. Okay. Haywood versus Site 4 DSA owner.
Good afternoon, Your Honors. George Haywood, Plaintiff Appellant Pro Se, and may it please the Court. The litigation before this bench today centers on a contract that I signed with my landlord. Offer, acceptance, consideration, reliance. I relied on this contract, which was...
So, counsel, you're talking about... Sorry, you're an attorney, right?
Yes.
Okay. So you're talking about the elements of a contract, but didn't you rent an apartment in a residential unit? It's a very complicated structure, right? condo unit with building with three residential units and 4 commercial units, and one of those 3 residential units was market rate. So you rented an apartment in the market rate unit, right?
Yes, I did, Your Honor.
Okay, and wasn't there a regulatory agreement that specifically excluded your market rate apartments from rent regulation?
Not exactly, Your Honor. When I rented this unit, the condo declaration, which sets up the market versus the non-market rate units, didn't exist yet. But
Didn't what?
the condo declaration, which is filed in July 2021,
Your
sets
apartment isn't listed in the rent stabilized units.
the regulatory agreement was not yet released when I moved into the apartment. So the provisions that you are referring to were not activated yet. But
When you
aside-
moved in, you were paying market rate rent, right?
Yes. And under 421A, when you pay market rate rent, it can still be rent stabilized. And Carano holds that you can make a contract that can mirror rent stabilization. And in fact, in that very regulatory agreement, that's just what the landlord does with the city. So what I'm talking about is independent of the regulatory agreement, independent of the 421A statute. I signed a contract, which I certainly relied on, which was completely written by the landlord. And if you look at respondent's brief, the
You're
pattern...
talking about the rider now, right, counsel? You're relying very strongly on the rider.
Yes, I am, and it's particularly record page 142. The fact that we agree to the terms of the rider, which is what we both executed, and that is going to show us an intent to be bound by contract, which we aren't going to be able to find in any of the cases respondent briefs. We're not saying...
So is it your position that one can contract for rent stabilized status?
Not that would, it's all about privity, not vertical privity that would run with the land, but you and me, that we agree that this unit can be that. Yes, we see it in Quran.
Where does it say that you and I can agree that your apartment is going to be rent stabilized?
Just
where
the
anywhere in the law does it say
Carano
that you
v.
can do
Castro, 546 v. Smalls. I think you can find it in the regulatory agreement itself. The key thing is the payment. But
The regulatory agreement itself says that your entire building, your entire portion of the building, consisting of 142 market rate apartments, your entire unit was excluded. And you're saying that notwithstanding that, the rider, the attachment of the rider made your unit rent stabilized.
the first question you asked was just where at law does it say that you can do contractual rent regulation?
How you can override the regulatory agreement and how you can override the land disposition agreement accorded between the city and the owner.
The regulatory agreement, we're not overriding. The regulatory agreement simply releases it to 421A law, where the first ever unit is still going to be rent stabilized. And the current law, after the Housing Stability and Tenant Protection Act, says that all 421A's 16 units are subject to the deregulation provisions at law. The deregulation provision at law is a high rent vacancy deregulation, and the unit's
Your
never
apartment
been.
was never rented before you moved in, right?
No, I'm the very first. I am the
So
initial.
how could it be deregulated if you were the first tenant?
Because in this case, I rented the unit prior to the building completion, and therefore a vacancy did not have the ability to occur. So December 15th, 2020 is when the consideration exchanged hands. December 16th, 2020 is when the unit is the completion date via the restrictive declaration for 421A. So this is an example of absolutely no vacancy whatsoever, and the only deregulation allowed at law is with a vacancy, which this unit does not have. And the regulatory agreement is separate, and 420 is separate. Everything is riding on that 142, because we both agreed, and that's backed up by Carano and the U.S. Constitution. That's my time.
Red light.
Thank you.
Thank you.
You have time in rebuttal.
Good afternoon, Your Honors, and may it please the Court. Deborah Riegel from the law firm of Rosenberg and Estes for the respondent. I want to pick up on what Justice Rodriguez
Gonzalez.
My apologies, Gonzalez, and my apologies to Justice Rodriguez.
I didn't become a man yet.
Not yet. Picked up on. In the world of confusion about rent regulation, and we have certainly all been a part of a lot of it, this is not a case where there is any confusion. You have a land disposition agreement and you have a regulatory agreement that are crystal clear. There are 121.
Were those in effect before plaintiff took his?
Yes. Yes.
Got his
Both
lease?
agreements were in place before the lease was executed.
Although we're in 2017, when did the lease get signed?
The lease was signed in December of 20. Both agreements were in place. Both agreements unequivocally provide for two classes of units in this development. Market rate units, which you just heard counsel concede that he lives in one of those units at a market rate rent.
So we have to be careful here. It's an apartment. The term, it's very confusing because normally in a condo building, you would call each apartment a unit. So if you could make the distinction, it'll be much better for us.
No problem, Your Honor. Counsel lives in a market rate apartment. 421A16 is crystal clear that when you move into a unit in a 421A16 building and that rent exceeds what was the luxury deregulation threshold, that unit is not subject to any regulation.
Counsel, you indicated that it's all crystal clear, but the appellant is relying on a rider that says that he's in a rent-stabilized apartment. Can you address that?
Sure. I'm old enough to have been schooled by Judge Tom on opting in to rent stabilization by agreement of the parties. Even where it benefits the tenant, the law in this department is clear. You may not contract into rent stabilization. It is a creature of statute. You are or you aren't, and in this case, counsel is not.
Counsel, what about his argument, the plaintiff's argument, that the regulatory agreement encumbers the Resi 3 units, which he was a Resi 3 unit, until the regulatory agreement is released for Section 8 of the regulatory agreement? What about that
So a
argument?
couple of things. The land disposition agreement makes it very clear that the market apartments were never subject to the regulatory agreement in Section 204. The sections of the regulatory agreement, Section 4 of the regulatory agreement on which counsel relies, are all very clearly referencing only the affordable restricted units. They talk about income certification. They talk about the application process. They all relate only to the regulated units. And most critically, the section on which he relies specifically directed the owner to register those units set forth on Schedule B with DHCR, and his unit was never.
Schedule B took a lot of magnification, though. That was a very poor exhibit.
Horrible document.
But I agree with you. I didn't see that, and counsel, I'll hear from your opponent as to whether it appears on that schedule or not.
There was no factual dispute below as to whether it appeared on Schedule B.
Okay.
It is undisputed. The only other point I'd like to make with respect to the vacancy very quickly, because I know my time is up.
I'll give you 30 seconds.
Counsel would turn the entire law of 421A on its head by suggesting that the first tenant under a 421A16 program can never be subject to deregulation. By his argument, contrary to DHCR, contrary to HPD, as codified most recently by DHCR when the new rent stabilization code was enacted, the first tenant in a 421A16 building is not subject to stabilization unless the rent is below the threshold.
Thank you. Please.
Thank you, Your Honors. One thing I do want to just make clear in my rebuttal is when I talk about the 142 record lease, I'm not saying the full rent stabilization rights which go with the land. That lease writer on record 142 is saying, in addition to rent stabilization payments, the landlord gets additional stuff. There would be no reason to have a signature line. I'm not asking you to change 421A law. I'm not asking you to overrule the regulatory agreement. I am merely saying me and the landlord signed something, and that should mean something in the law. On 421A, basically it all works on a vacancy.
About the concept of mistake.
There can be no mistake if you read R142, because I say I'm agreeing to the intents, to all the terms and agreements of this document. And if that were to have no force of law, there would be no reason to put it in.
Is your lease a standard rent stabilization lease?
I don't think it
You
was.
may not be familiar with
the
it.
rider was there. The rest of the lease is not the 1 or 2 year standard rent stabilized lease, but the 421A lease rider was in there, and there was no notice given to me. And I have to say this again, it was completely and solely written by the landlord. So it would be, if it were a mistake, it would be read against the landlord. And if it were a mistake, then you wouldn't see, if you pull up the DHCR records, rent stabilized unit name for my unit.
Is it your argument that you should be treated similarly to the tenants residing in the buildings Resi 1 and 2?
Absolutely not, Your Honor.
No, don't interrupt me.
Sorry.
Thank you. That you should be treated similarly to the tenants in the rent-stabilized buildings, Resi 1 and Resi 2?
Absolutely not, Your Honor. Merely that the price I agreed to pay reflects the rental board guidelines. And when I leave the unit, that's it. So it's just a
What do you
deal.
mean that's it?
It does not, it's direct privity, not vertical privity, does not run with the unit, whereas rent stabilized would run with the unit.
Oy.
Until
So it's solely a creature of contract, is what you're saying.
yes, exactly. And the other thing is, this is so key, 421A operates on a vacancy. And this unit simply didn't have a vacancy because it was signed and rented so early. And finally, what the Housing Stability and Tenant Protection Act says is all the rental stabilization provisions at law before June 14th, 2019, but the one they're talking about, 2520.11P4, was effective November 8th, 2023, and I briefed that in the reply brief. Thank you so much for your time, Your Honors.
Thank you both. People versus Johnson.
May it please the court, Matthew Bova for Mr. Johnson. Under Jimenez, the search of the...
What's your name?
Oh, Matthew Bova for Mr. Johnson,
And where are you from? What firm are you with?
from the Center for Appellate Litigation.
Oh, thank you.
Under Jimenez, the search of the bag was unconstitutional because, on this record, there was no reasonable basis to believe that Mr. Johnson could have somehow managed to access that bag. Mr. Johnson...
The bag was 2 feet away from him, correct?
No, Your Honor. I don't think that's a correct characterization of the...
How would you characterize it?
The key question is
No,
access.
I'm asking you, how far was the bag?
I think it's more like 8 feet because where his hands are...
Where do you get that from?
So the bag is approximately 2 feet from his feet.
Right.
Yes, but that's not the relevant question because one cannot access a firearm with one's feet. It's the hands that matter. It's the wingspan that matters under Goki and under Jimenez. And what happens here is he's lying, Mr. Johnson is...
Was this a handbag or a pouch?
A pouch. So Mr. Johnson is lying face down on the bed. One officer is on top of him, has rear handcuffed him, already frisked him. He's totally cooperative. Another officer has also participated in the frisk and is standing by. And another officer is standing by his legs, holding his legs. This is a police-dominated environment. Under Jimenez, it's not enough just that there be property near someone at the time of the arrest. There must be evidence that it's in the grabbable area, which we do not have here. Because this firearm, and as to grabbable area, that's the court's decision too. The court does not find that this firearm is in Mr. Johnson's grabbable area. Instead, what the court finds is that it could only become in his grabbable area, if he somehow managed, while rear handcuffed, belly down, to roll off the bed after getting out of this police-dominated situation, jumped to the bottom under the bed, and somehow managed to access a bag while he's rear handcuffed. That is next to impossible.
Counsel, the pouch as well, it was zipped shut, is that correct, or am I mistaken?
Yes, Judge. Yes.
So we'd also have to unzip the pouch
Yes,
in
Judge.
order to access the firearm, because the officer felt the firearm through the pouch, correct?
Yes, the officer, while he reaches down and feels it, yes, and then passes it to
So if
Sergeant
you
Daly.
could feel the firearm through the pouch, I don't want to go towards the record. Presumably, you could fire the firearm through the pouch. Yes?
That seems like a strained possibility. I suppose it's possible, yes. But I don't think, the question is not whether that's not the operative question, though. The question is whether he could have gotten his hands on that bag. And there's no...
Counsel, the fact, do you equate the fact that he is handcuffed to him being totally immobilized?
On these facts, mere handcuffing, no, Your Honor. But on these facts, it's a lot different than a lot of prior cases, such as Wiley, where there's handcuffs. And on these facts, he is totally immobilized, because not only is he rear handcuffed, but he's on the bed, belly down, with an officer on top of him, 2 officers around him. I think a good contrast are cases like Wiley, cases like Johnson. In those cases, it's the traditional situation where someone is standing up handcuffed, and there's a bag at their feet.
Is the focus whether the defendant is immobilized or whether the police have exercised control over the pouch?
It's both, Your Honor, because those two get at the central inquiry, which is under Jimenez, grabbable area, and whether there's a reasonable basis to believe that the suspect may access the firearm. And on these extreme facts, there is no reasonable basis here.
So you're asking us to find that there's no valid search for any possible firearms in a situation where the defendant allegedly committed a gunpoint robbery and rape and had violent propensity and had absconded previously from what was it? Parole. Yeah.
So that would go to the prong of whether there's a reasonable basis to believe that the container contains a firearm. But that is not the operative question, and that's not the sole question. Additionally, under Jimenez, the government also bears the heavy burden of showing that the bag is accessible and that it is within the wingspan.
Let's talk about standing here. Was Mr. Johnson arrested in his home?
No, Your Honor.
He was arrested in someone else's home?
Yes.
Did he assert any possessory interest over the pouch?
He did not admit possession, but under Burton and Ramirez-Portorial from the Court of Appeals, that's not required. Instead, the defendant can simply rely on the evidence presented at the hearing. And here the evidence is Mr. Johnson is on a bed. There's a bag under the bed. There's only one.
A bed that's not his, right?
No, the bag is his.
Bed, BD, bed.
Oh, sorry.
You're right.
Well, that is... No, for the purposes of standing, we're not asserting that he owns the bag or he owns the bed or he owns the apartment, but he owns the bag, and that's...
And the bag is under the bed, right?
Yes, Your Honor.
It was not visible next to him, correct?
Yes, Your Honor. Okay. Well, it's under the bed. He's the only person in that room. There's one other tenant, his girlfriend, who denies possession, and the government indicts him and charges him through felony complaint with possession of that firearm. That's more than sufficient to establish standing.
When you say government, you mean the people?
Yes, Your Honor.
Thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honors, and may it please the court. Jennifer Mitchell for the people.
Counsel, was the defendant immobilized? And is that the test?
Your Honor, that is not the test. He was in the process of being handcuffed at the point that Detective Cumming reached his hand under the bed and felt the outline of this gun. And Detective Cumming himself also had his hand on the defendant's leg to try and stop him from potentially kicking him or doing something else that could harm the officer's safety.
The improbability of the defendant rolling up into the fetal position, rolling off the bed, and then getting the bag, it sounds pretty far. How does that weigh in?
Your Honors, Detective Cumming was very clear in his testimony that at the time that this search was occurring, he believed that defendant could have reached that bag and fired the firearm. And I think it's important to remember how quickly these events unfolded that night. This all happened within a matter of seconds, if at most a minute. And from the officer's perspective, he thought at that time that defendant could have rolled over on the bed, reached under, and grabbed that firearm and potentially harmed the officers that were in the room. And what the analysis is whether the exigency was at the time of the arrest. And that is the case here. At the time
Does it make a difference? Once the officer retrieves the pouch, it's secured.
Yes, Your Honor, it was at that point, but again, he felt the outline of a gun through the pouch before it was.
Are you saying now probable cause to search because he felt the outline?
I'm sorry, can you repeat that?
Are you saying that by him feeling the outline, he now has independent probable cause to search the bag? Is that an argument that you made below?
The people did not make that argument below, and we won't rely on it here since that is not the issue on appeal. But the people's position is that feeling the outline of a gun, the officer could tell that this was a gun, no questions asked. He could tell exactly what type of firearm was in the bag simply by the outline. He could tell that this was a revolver. And so at the time he pulled the bag out from under the bed, he passed it off to the other officer in the room, who then proceeded to open it. But again, this all happened very quickly, in quick succession, at the same time defendant was arrested and in the process of being handcuffed. And through those actions, this was a valid search incident to arrest. And then I'll just conclude on the point that this all doesn't matter because defendant did not have standing to contest this search because the apartment was not his, and even if the bag itself did belong to defendant, it was located under the bed in this apartment that he did not belong in and was specifically prohibited from being in by his parole officer.
And for all of course, this was addressed at the trial court, right? The standing issue was argued.
Yes, Your Honor, exactly. This was already addressed below, and the court specifically found that defendant did not have standing to contest this, but found in their decision on the merits.
The lower court, I'm sorry, go ahead.
No, I'm sorry, go ahead.
The lower court didn't rule on possessory standing, right?
Not with the bag itself, Your Honor, that's correct.
So that's not something that we could rely on, correct?
Correct, yes. And so if there are no further questions, then we would ask that you affirm. Thank you.
Thank you, counsel.
Yes, Your Honor, I think that's the point, too, is that the trial court did not confront the question, which is really irrefutable, whether one has standing to challenge the search of a container that belongs to you. There is no question that you have a privacy and possessory interest sufficient to confer standing under those circumstances. And there is not a reported case in this entire state that holds to the contrary. That would work a radical change in law. But procedurally, the government didn't raise this argument. The government suggested
What government are you speaking of? Could you be precise and just say people?
Yes, Your Honor.
Thank you.
The people did not raise this argument below. The people slightly suggested it in the middle of the hearing that perhaps Mr. Johnson would not.
They did. I think they were unequivocal in saying that standing is the whole case, but then they forget to argue it.
They didn't argue it at all at the end of the hearing.
Right.
And therefore, it's not only unpreserved, but it's basically waived, too, because the people suggested that they may be able to have a standing argument, and then at the end of the hearing, totally silent.
Counsel, are you familiar with the facts on People v. Smith?
Yes, Judge.
How is that distinguished? How do you distinguish that case? That's the fair beat with the bulletproof vest.
Sorry, Your Honor?
That's the case with the fair beat and the bulletproof vest.
Yes, Your Honor. So Smith is different because it's, again, one of those cases where the bag is accessible. The bag is within the grabbable area.
Well, when they searched it, it was a briefcase there, right? The police took the briefcase off of the defendant. At that point, it's secured.
Right, but under those circumstances, that's the kind of case where you have someone standing and there's property next to them that they could lunge and grab. Here, though.
Well, he had it in his hand.
Yes, right. So it starts, the bag is directly accessible.
What I'm getting at is at the point that it's secured. Because if it's about that the police have total control over the bag, that happened here too, right? So they had total control over the briefcase in Smith, and here they had total control over the pouch.
But in Smith, it's basically on the platform. In this case, so in that case, all that would be required was, the typical act of just lunging for something that's on the ground. Here, though, what would have to happen is he would have to somehow manage to, with what amounts to the strength of Hercules, hoist one officer off him while he's rear handcuffed on the back, somehow manage to spin onto the ground while 2 other officers are present, and then after doing all that, manage to access the bag. That is an impossible possibility on this record, and therefore exigency was not established.
Thank you, counsel. Thank you both. Okay, we'll hear from the appellant in Noy.
Good afternoon. Gary Tracton from Cudman Tracton Allo Posner. May it please the court. I'm here really to present the oral argument because I think this case is important because it's the very first time that I think a court is going to construe the no theft, the No Wage Theft Loophole Act. It has been addressed by a number of courts, but in every single case that I've been able to find, they've said it doesn't apply because it's not retroactive. And so this is the first time.
Right, this is all post-Loophole Act effective date conduct.
Right, exactly. And so in terms of sort of saying what the act does, what we've been able to do is take some of those cases, a number of those cases, and say by implication, because they've said, you don't get to make that argument here because the statute is not retroactive. As a matter of fact, I think it was 4 weeks ago today, this court had a decision. The case is Canton versus Tagstone, and it says the complaint alleges a wholesale withholding of $977,000 in wages for a given period rather than a deduction, and the No Wage Loophole Act, as amended, does not apply retroactively. So it has sort of the same implication that those other cases did. In any event, so the real question here is this just a contract claim or is it also a labor law claim? Now, the lowest hanging fruit is the Section 215 claim, because
that's the retaliation claim. The retaliation claim.
Retaliation claim, right? Because what Judge Ostrager was a very simple decision, and he just said that the defendants persuasively argued a controlling case law mandates that the facts do not give rise to claims under the provisions of the New York law cited in the amended complaint due to plaintiff's position as a highly paid executive. And the Pachter case just did away with that. That used to be, you know, I've been practicing long enough to remember when that was sort of in circulation, but that argument was no longer in circulation. And especially, there's never even been questions in the case law about how much you make and are you executive and all that when it comes to 215. But I think the importance of the new statute is that all of the case law that comes before it has to be sort of put off to the side and say, where are we now? And except for those cases which are consistent with the legislative findings in terms of certain courts have found Ryan to already decide that you can bring a 193 case, no matter 193 is the deduction statute, regardless of your executive status. As a matter of fact, 198 itself talks about you know, all employees is now, and 193, et cetera, et cetera. Now, it's a little hard for me. You know, I came here also because initially I thought I'd just save all my time for rebuttal, you know, and there's no rebuttal to make. So I'm here really to answer questions primarily. If you have some issue that was left unaddressed.
I think your papers were very complete, counsel. Thank you very much.
Okay, thank you very much.
Okay, the last case is 120 Lexington Avenue versus Wesco.
Good afternoon. May it please the court. Kevin Buckley, Mount Cotton, Mullen, and Greengrass for the appellant, Wesco Insurance Company. This case should have been dismissed on 2 different grounds. 1, contractual suit limitations, and 2, res judicata. This case began back about 4 years ago, and it was dismissed because Wesco attempted several times to get discovery and made motions, and The trial court eventually granted our motion under
Dismissed with prejudice.
It is with prejudice because it was a preclusion order. It wasn't just the failure to show up at a conference that caused the dismissal. There was a preclusion order that precluded the plaintiff from introducing any evidence regarding the subject discovery. And if we look at what the subject discovery is the entire case. It was the interrogatories. It was the discovery and inspection. And most importantly, as stated in the affidavit of noncompliance, it was the supplemental claim. That's what this whole case is about. If you look at the insured's attorney's letter before the suit, which is at the record at page 59, he tells us exactly what this case is about. Simply stated, he says, we seek to supplement the claim based upon the information as to the scope of damage that was not known or knowable at the time. That is exactly what the discovery was going toward, and that's exactly what's stated in the affidavit of noncompliance. Thereafter, attorneys didn't show up at the conference, and the court dismissed it based on 32-31-26 and issued the based on the preclusion order, as well as 22 New York CRR 202-27 for the failure to appear. So there's
Counsel, can you speak to the issue of whether 122-24 Lexington Avenue Corp is in privity with 120 Lexington Avenue Corp?
It was unknown to us. It appeared at the outset of the litigation that they were not in privity, and this was a different company. But I'm informed now that they merged at some point before the last time we were before this court, which is surprising. So I don't dispute that they would have privity since the merger occurred after the loss occurred. So in that instance, I'm not going to dispute the privity aspect of it, but they are bound by all of the obligations of the original insured, which includes commencing suit within 2 years of the date of loss, which they originally did. And then their suit was dismissed. And then they came back some close to 6 years later, and the contractual suit limitation period is 2 years. They came back almost 6 years later and sued again. CPLR offers an escape for some people under CPLR 205A under certain circumstances. If you sue within 6 months, they did not. They sued 9 months after this court's decision dismissing the case, and it doesn't allow that escape provision if the dismissal was based on failure to prosecute, which the dismissal was in part because it was under 202.27. So based on suit limitations alone, it should be dismissed. Now, there was nothing precluding the attorneys from commencing suit within 2 years because they, in fact, they did. So the argument, I can't understand in opposition that there was some reason they could not commence suit within the 2 years and cited to Executive Plaza. That just does not apply here. As this court said in Farage v. Associated Insurance, Executive Plaza is distinguishable as plaintiff here failed to allege she reasonably attempted to repair the property within 2 years and was unable to do so. There's no allegation in the complaint. There's no affidavit in opposition to the motion to dismiss that alleges such things. So it's just inapplicable. So
I'm sorry. Was the court ever informed that there was a merger between 120 and 122 Lexington?
No.
And were you informed?
I was not. And apparently this happened well before in the first case, well before it came before this court, and this is new news on this new litigation.
Thank you very much, Counsel.
Thank you.
Good afternoon.
I know you're going to bring the microphone down.
Oh, yeah, I'm a little vertically challenged. Good afternoon. Can you hear me better now? Okay, my name is Deborah Denenberg with Denenberg Law. I'm representing the respondent plaintiff in this action.
So can you explain why this case shouldn't have been dismissed based on res judicata?
Well, one of the things I was going to point out exactly is that the original dismissal was not based on a motion, like in the Holly case, and the conditional order that counsel keeps bringing up, counsel fails to tell this court that the discovery was completely done.
But it was a
Everything was-
self-executing preclusion order. It didn't need another document.
I'm sorry, Your Honor?
It was a self-executing preclusion order, as I recall.
But it's a conditional order of preclusion, and there was no non-compliance. In fact, there was full compliance. And what appellant's office keeps forgetting to tell this court, in fact, the commercial rules say candor is key, and they have not been candid. They are using procedural gamesmanship, which is not permitted by the commercial division
I'm
rules.
surprised that you're accusing not your adversary, but the other side of gamesmanship. I'm looking at all of the dates on the compliance orders and everything that included warnings saying you haven't complied with discovery, you haven't complied with this. Warning, you are subject to an order of preclusion or an order of dismissal. So who was engaging in gamesmanship, please?
Well, the fact that counsel has not been candid, that it was all done, and the court scheduled a conference for May 6th. We had worked out a stipulation to certify the case so I could file the note of issue. There was one minor piece of
So was there a motion to restore the matter or to vacate the dismissal or an appeal?
Yes.
Any of that? Okay.
And I was unsuccessful.
All right.
Being candid, I was unsuccessful. But we were in full compliance, and in fact, Judge Bannon's
Why are
order.
you bound by that? You got an adverse order, you moved to vacate it, you were unsuccessful, so why isn't that a valid basis for res judicata?
Well, because there's still an ongoing breach of the of contract by the defendants. They're still holding the holdback. That's what this is about. There's a holdback that they are holding pending the completion of reconstructing the building, which we were delayed in doing because of Con Edison and the building department. And in fact,
Everything that you're saying speaks to res judicata, doesn't it? Same claim, same parties.
but the breach of contract is ongoing. It hasn't even, the statute of limitations on the breach of contract hasn't even run yet because they're still breaching the insurance contract in keeping the
You're talking
holdback.
about a continuing wrong?
Yes.
What about the 2-year statute of limitation in the Wesco insurance policy?
Well, they haven't paid the whole policy yet. So it's an ongoing breach. They're still in breach at this point because they're holding $122,000 holdback. And if
Could you sue them 10 years from now?
well, if you look at Executive Plaza, until the building is
What does the 2-year limitations period mean?
well, it doesn't. If you cannot rebuild the building because of circumstances beyond your control, yes, when you meet the prerequisite of rebuilding the building, then the statute of limitations begins to run. And the Executive Plaza case.
That's novel.
The Executive Plaza case is directly on point. It's literally a place where they had a fire and they kept the holdback. And then the case was dismissed as premature because they were still holding the holdback. That case is directly on point. And in this case, they're still keeping the holdback. That's why we commenced another action. And
So you're saying that the preclusion order doesn't apply to you how?
well, it's a conditional preclusion order, and we complied with the preclusion order. So there's no basis to preclude us at this point. We had been in constant contact with West Coast Council repeatedly. We had many depositions.
You moved to vacate that, but you didn't appeal from it, right?
I did appeal, and I was unsuccessful.
That's the one, yeah.
That's right. So
I'm being candid, but
So if you were unsuccessful, how do you want us to undo something that we already did?
well, we started another action based on the continuing breach. They made a motion for summary judgment, and what we are
Can you start another action if
If the action is in relation to the same action that was dismissed, that was appealed, and the appeal was denied.
It wasn't with prejudice.
Oh.
It
Thank you,
wasn't with
counsel.
prejudice. And may I point out that we're actually appealing now from Judge Adams' order, which is on page 4 of
No,
the
we
record
know why
on
we're here.
appeal.
That's the decision on appeal. We understand.
Right, and Judge Adams did not find that it was with prejudice. In fact, she actually said, continue discovery, and then
But
you
she
can make
said
your...
no, but she said your motion to dismiss is denied without prejudice to do discovery. That's all she said.
Well, she didn't
Counsel,
grant...
thank you very much. You can sit down now.
Thank you.
On the issue of res judicata, I just wanted to mention one additional case that I failed to cite in my brief. It's Barrett v. Casco Construction from the Court of Appeals, 5-6 New York 2nd, 830. And the court, it's a one-paragraph decision. In there, the court says, where the judgment does not say it's on the merits, it should be given res judicata effect in order to prevent plaintiff from circumventing the preclusion decree. I think that's directly on point here with what we have.
Would you clarify the allegation that your client was engaged in gamesmanship?
I'm speechless on that one, Your Honor. I have no idea what is being talked about there. I believe the record clearly shows the efforts we went through time after time to get the discovery and going back to the court, getting order, getting warnings, and then the conditional preclusion order, and then the failure to comply that led to the original dismissal.
Thank you, counsel. Anything further? No?
What's up?